Dear participants, ladies and gentlemen, let me first wish you a very warm welcome to this panel discussion celebrating the 10-year anniversary of the entry into force of the 2012 version of the WTO Agreement on Government Procurement, which entered into force in April 2014. My name is Philippe Pelletier from the WTO Secretariat, and I will be your moderator for this session. I'm delighted to have with me today two very distinguished experts. Before briefly introducing them, I would like to mention that detailed biographical information will be made available on the WTO webpage for the GPA knowledge series. I will therefore keep this introduction to a very strict minimum and just mention a few highlights for each of them. First, Jean Hellman-Greer is the trade principal with JAG LLC, a consulting firm. She has extensive experience in international trade as a U.S. trade negotiator, lawyer, advisor, and consultant. Of particular relevance to us today, she served as the senior procurement negotiator at the Office of the U.S. Trade Representative, the USTR, where she was the U.S. negotiator for the negotiations of the 2012 version of the GPA and other trade agreements. Robert D. Anderson is honorary professor at the School of Law at the University of Nottingham in the UK and is on the part-time external faculty of the International Master's Program in Public Procurement Management of the University of Rome, Tor Verkada, and its sister program at the University of Belgrade in Serbia. Until March 2019, he was senior counselor in the Intellectual Property, Government Procurement and Competition Division of the WTO, where he worked for more than 20 years. Of particular relevance to us today, he served as secretary to the Committee on Government Procurement for many years, including during the negotiation of the GPA 2012. Welcome to both of you.
Thank you, Philippe.
Excellent.
Thank you.
Now, let's get started.
Good afternoon, Jean.
As mentioned at the beginning, the topic of today's discussion is the 10-year anniversary of the entry into force of the GPA 2012, which entered into force in April 2014. I would first like to ask Jean Hellman-Greer to take us back to the very beginning of the negotiations. When did you start the negotiation that led to the GPA 2012, and why was the negotiation initiated in the first place?
Thank you, and it's a delight to be here and to join in the celebration of the 10th anniversary of GPA 2012. But going back a couple decades, the negotiations of this agreement began in the late 1990s. Within 3 years after the WTO 1994 agreement was put into effect in 96. And it was based upon a mandate in the agreement that negotiations would be undertaken within 3 years to seek to improve the agreement. And there were basically two issues that were sort of prompting the negotiations, because a mandate really obviously requires the parties to have an interest in actually doing something under the mandate. And the first was on market access. The 1994 agreement expanded the coverage of the GATT code extensively. It added subcentral entities, utilities, services, government enterprises. And in those negotiations, not all the parties were prepared to offer the same level of coverage. They had their own domestic issues, and so they sort of offered what they could. And rather than accept a lowest common denominator in which all parties offered the same thing, the parties agreed to allow the parties to sort of distinguish who they provided access to. So they put in a number of reciprocal clauses, which basically were, if party X opened a certain sector and party Y did not, party X could say, I'm not going to give access to party Y to that procurement until they offer reciprocal access. So one of the goals of the negotiations of the 2012 agreement were to basically try to smooth out some of those differences, fill in the gaps, and hopefully remove some of the reciprocal conditions. So that was on the market access side. On the text side, the rules and the rules of the agreement, there the issue was to try to make it a little bit more understandable in terms of the text. In the 1994 negotiations, there had been a lot of additions to the text, but they were basically added on. So you had, and other additions had been made in 1988 when the GATT code was amended. So you had an agreement that had sort of everything piled together, but no one had sort of taken time to kind of see if it all fit together. So one of the goals of the 2012 negotiations was to really see if there was a way to make the text more comprehensible. And that led to a complete overhaul of the text, basically tearing it apart and putting it together again in a way that made sense. Now, the parties did not all have the same interest in these negotiations. The four principal parties were what we then called the Quad, which was Japan, the European Union, Canada, and the United States. And so these four parties were basically leading the negotiations, but they didn't all have the same interests. The US was quite satisfied with its 1994 market access, and so it was not a big demandeur in the 2012 negotiations on market access, but it did have a strong interest in the text. And so it took a leadership role in terms of revising the text. The European Union was more interested, or was very interested in market access and basically trying to remove some of or fill in some of the gaps in the coverage. So you had sort of two different sets of aims and goals, and other parties obviously had their own interests, but I think the US and the EU were sort of in a sense, the two principal parties that sort of helped set the agenda for the agreement. When you look at why we were able to do a renegotiation then, but not now, I think, times have changed and there's a lot of different political considerations, which have made it very difficult for the parties to initiate a new set of negotiations, even though that is called for in the 2012 agreement. So I'll stop there, and I don't know if Rob has anything he wants to add.
I certainly agree with everything that Jean has mentioned. I might just mention one other part of the updating that was necessary, and she's completely right. A comprehensive updating was necessary. But the agreement was materially out of date in one respect, in that it did not cover e-procurement tools in any way. So that was sort of one specific motivating factor concerning the text.
Yeah, it's still provided for faxes.
Right.
And the faxes were not quite so up to date.
I wonder if you and I are the only ones present who know what a fax is.
That could well be. We won't ask, though.
Well, thank you very much, Jean Greer and Rob Anderson. If you allow me, Rob, I'll continue with you for the next question. As you know, the GPA 2012 negotiations took place in parallel with the wider WTO Doha round of negotiations, which covered agriculture, industrial goods, and services. So the GPA 2012 renegotiation resulted in a very significant additional market access package opportunities for exporters from GPA parties. I think it's been estimated to be worth approximately between 80 billion to 100 billion US dollars annually. So that's quite significant. And at the same time, the GPA also covers services. And if you contrast that with the wider WTO Doha round of negotiation, which has not yet produced any trade liberalization results, with limited exceptions, for example, with the elimination of agricultural export subsidies. Can you explain that a little bit? How do you account for this stark contrast between the GPA negotiation and the broader results achieved in the Doha negotiation round?
So thanks for that, Philippe. And it's a delight to be here with everyone. And I'm so glad that you are pursuing this effort with the Advanced Global Workshop on Government Procurement. That's really terrific. So greetings to everyone present, and of course to you, Philippe. So I would mention, in my mind, there are kind of three main factors that help to explain the success that we had, or that the parties had, in renegotiating the GPA in 2012. And so the first is the plurilateral nature of the agreement. And it simply is easier to have a renegotiation when it's a smaller number of parties. This is a very simple and basic thing. And the parties to the GPA, you know, all knew each other, and were keen on the negotiation in principle. And then that leads exactly into the second point, which is what I call the underlying degree of like-mindedness among the parties. And what I mean by that is that all of the parties, honestly, in my experience and from my conversations, from my observations, every single party to the 2012 renegotiation believed in the agreement, believed that it could be an instrument of trade and also of development and good governance, wanted the renegotiation to succeed. And I say this despite, our wonderful colleague, Jean Greer, and it's so great to be on the panel with her, is absolutely right that there were, you know, differences in the level of ambition amongst the different parties, especially with regard to the market access side. But and that's completely true. Yet I would insist that the EU, the US, but also, you know, Japan, Korea, Singapore, everybody around the table wanted this renegotiation to succeed, and was committed to the agreement and believed in the principles of the agreement. And I guess the third factor that I would mention would be that would just be, and this, you might think this was kind of unfair, but I think some of the parties actually especially wanted a success in the area of GPA, in part to take attention away from the lack of progress on the wider DOA issues, or at least to be able to say, look, true, we haven't succeeded yet in the DOA round, but we can do things in the WTO. And here's this significant success in this important plurilateral agreement. So I think that was part of it too. I certainly think that was part of the motivation for the directors general at the time, who definitely very much wanted this renegotiation to succeed. And I think it was an important motivation for the parties as well. And Jean, any points you'd like to add are extremely welcome. And it's great to be here with you.
No, I don't think I have anything to add. That was a good summary, Rob.
Okay.
Thank you very much, Rob. And that will allow me to continue with Jean Greer. Although ultimately successful, the renegotiation, the GPA 2012 renegotiation did take a fair amount of time. So I would like to invite you to tell us about some of the difficulties that GPA parties encountered along the way that held up the completion of the negotiations.
Thank you for that question. You are correct that the negotiations took a long time. As I noted earlier, they started, at the very end of the 1990s, and they didn't conclude until 2012. So it was more than a decade. the parties started the negotiations with the text because there was a greater sense of common views in terms of renegotiating the text. But that still took quite a long time as we sort of took the whole text, took it apart, figured out what we needed to include and what we would not include. And there, one of the goals was to make the agreement as comprehensible as possible. So we stripped out provisions. If none of us could explain why a provision was there, and we talked to our domestic procurement offices and said, does this make any sense? And the answer was no, we just took it out. So I think it's a much more streamlined, logically arranged agreement. But that still took time. But we finished those negotiations in, I think, the end of 2006 on the text. And then there was a debate whether we take the text and put it into effect as it was, as they had done in the 1988 amendment of the GATT code, or whether we waited until we finished the market access negotiations. The U.S. and some other parties would have preferred just to get the text in place so it could be used immediately, but that was not a consensus of all the parties. So instead, what we did was reach a provisional agreement and called it a provisional agreement on all of the text except for the last provisions. And then we basically did the legal verification of it, the translation issues with it, and then just set it aside. And then moved to in-depth discussions of market access. I mean, market access had been sort of, out all the time, and there'd been some discussions, but this really started more of a focused effort with regard to market access. There'd been a point about maybe a year or two before that when we had started the market access negotiations by doing a request offer process. Every party would request what they wanted from the other parties, and then the parties would respond with their offers. And that showed both what parties wanted to add and also what parties were prepared to add. And frankly, there was a huge gap there. And so that, starting the market access negotiations, proved challenging. They were very difficult. There was just a lot of contention in terms of between some of the parties. And frankly, one of the issues was that the US was not in a position to offer much more than it had in 1994. And that created some tensions with some of our dear colleagues. And the Secretary was very helpful in this process, sort of in two ways. One, they did a roadmap about, I think, 2010 that sort of set out all the issues that were outstanding at that point: market access, the remaining text issues, how to implement the agreement, and the work programs, and sort of showed a path forward of how they could be resolved. And that helped move the discussions forward, but it did not move them to resolution immediately. What finally led us to conclude the agreement was at the end of 2011. And this kind of picks up a point that Rob just mentioned about interest in the broader WTO with regard to what was happening in the GPA. So when they were preparing for the 8th ministerial of the WTO at the end of 2011, the GPA parties were under strong pressure from the Director General and others who wanted to see some progress in the WTO. We were under strong pressure to come to closure on our negotiations, with the thought that if the GPA, even though it was a plurilateral agreement, could demonstrate that it could actually negotiate an agreement, that showed that the negotiating function of the WTO worked. And so that was enough of an impetus for us to basically find a path forward on the market access issues, and then finish up the text issues, and then come to closure. I think, Rob, you may want to add sort of the final moments of how we all came together, because it was sort of touch and go until the very end at the ministerial.
I thank you, Jean. I absolutely agree. We were not completely assured of success literally until the chairman's hammer came down that morning in Geneva. And so I have a little anecdote about that, which I'll save for the very end. But what I want to say is that another essential ingredient in the success achieved was the skill and tenacity of expert negotiators, very much like Jean Heilman-Greer. And I have nothing but admiration. They had to stay calm in difficult circumstances and look for flexibility at home, which wasn't always easy. I know that. And also look for innovative ways around the blockages that arose. So I think in reflecting on the factors that lead to success in these matters, we definitely must never exclude the skillfulness of the participating negotiators, Jean and others, of course, needless to say, the Quad members and lots of others as well.
Thank you very much to both of you. Jean, you mentioned that the results of the negotiations included both kind of a package of market access improvements, but as well as a new streamline and improved text of the agreement. So to continue with Rob, I would like to ask you, Rob, can you talk a little bit about the improvements and novelties included in the GPA 2012 text? For example, the new text includes a reference to corrupt practices, which is by itself quite remarkable.
Sure, Philippe. I'm glad to talk about that. I think the changes to the text that were adopted in 2012 and subsequently came into force were really significant. And I would put first and foremost the point that you mentioned, that is the new references to the prevention of corrupt practices and the avoidance of conflicts of interest. And here I would underscore two or three related points. One is that the references to corruption and avoiding conflicts of interest in the 2012 GPA were the first ever such references in any of the WTO agreements. And I think that's really significant. It shows in a way that the GPA, the Government Procurement Agreement, was kind of at the cutting edge in this respect. And I think that, and let's recall that in addition to, well, there's two elements really to the references to corruption and conflicts of interest. One is in the preamble to the agreement, the revised agreement, where you have this very significant, in my view, hortatory language concerning the prevention of corrupt practices and the cross-reference to the United Nations Convention Against Corruption. And this is all kind of path-breaking for the WTO. And then, of course, in Article 4.4, you have the substantive obligations for parties to conduct their procurements in a manner that avoids conflict of interest and prevents corrupt practices. This is groundbreaking and very significant. In my view, it reflects a couple of things. One is that, well, and I really credit the parties for being willing to take that step, and again, persons such as Jean for being open to this new development. And I think it reflects two or three things. One is that it's a fact that the public procurement sector internationally is vulnerable to corruption. And this is sad, and one wishes this were not true, but it's just empirically the case. And this is not, I repeat, not only a problem in developing countries, it's also very true in developed countries as well. I can't resist the opportunity to mention that together with colleagues, I've just finished a book on this topic. and which is just come out in the last few weeks, and it's called Combating Corruption and Collusion in Public Procurement. It's co-authored with Allison Jones and with William Kovacek, who's a very significant scholar in the U.S. and a former chairman of the U.S. Federal Trade Commission. And it shows very much that this issue of corruption and also the issue of supplier collusion is a concern that is present really is present in all economies. So I think it was really important and really good to take this step to include this language on the prevention of corruption and avoidance of conflicts of interest. It also was very much consistent with and built upon UNCAC, that is the United Nations Convention Against Corruption, and kind of a change of thinking, I think, in the World Bank as well, with much more emphasis on good governance as an underpinning of development. So I think all of these things were important and came together. So that's definitely the inclusion of that language for me, is the most important and kind of striking change in the text. But there were others as well. I would mention actually one that I think that is very seldom mentioned, but I think is really interesting and important. And that is the third recital in the preamble to the revised agreement, which talks about the importance of government procurement, the importance of the integrity and predictability of government procurement systems for the efficient and effective management of public resources. And I just think that's a wonderful thing. It reflects a change that took place that really, I think, around the negotiating table, the parties started to feel that this agreement wasn't just a trade instrument. It also had very important implications for development. And as the text says, the efficient and effective management of public resources. I think that's really, really cool and really important. Obviously, also the new language on concerning the use of e-procurement tools was important. And there the emphasis was, I think, twofold. One was to encourage the use of e-procurement tools, which are really efficient and effective in many, many ways. And the other, though, was to put in place some minimum standards regarding the use of e-procurement tools concerning, for example, interoperability of systems, electronic traceability, and so forth. I think those were important. There's another important change concerned environmental conservation, but I think we'll come to that later on. Thank you. Jean, forgive me for burbling on, and anything you'd like to add, please do.
Yes, I think we'll talk about the developing country provisions in another question, I think. But I think one other sort of major innovation in this agreement was a new process for resolving disputes about modifying coverage. Because I think it's important for parties that have put on, particularly government or enterprises, on their list. They need to have a way to get them off. And what we found in the negotiations, and Japan was the leader here, Japan had tried to take several entities off the list for, a decade, had not been able to. So what the parties agreed to, which was an innovation, was to set up an arbitration process that would have a final decision on this matter. And I think that's really an important step that they took. Thank you.
You're absolutely right. Thanks for mentioning that. Yeah.
Many thanks to both of you. Now I would like to come back to the package that constituted the results of the negotiations. As you will remember, it included three main elements. The first one, additional market access opportunities, then a new text for the GPA, and also a package of new work programs for the company. So my next question relates to that specific part of the package, the work programs. And I would like to turn to Jean Grieve for this question. Could you please tell us why the negotiators decided to include first a reference to the work program in the agreement itself, but also a package of agreed work programs for the committee? And why they just did not leave it up for the committee to decide whether they want to do additional work on specific topics at a later stage? And also, given that those work programs were initiated about 10 years ago and the work is still going on, what do you think of those initiatives when you look at them now? Do you think they were, the right ingredients to conclude the negotiations?
Thank you for that question. Let me start by talking about a couple of the work programs as to why they were established. And then I'll get to sort of the tougher questions. Looking first, there's one that requires the parties to look at small and medium enterprises and how the parties are supporting SMEs. And this work program came about because the U.S. and a couple other parties maintained preferences in their schedules. They reserved certain procurement for their domestic suppliers. And there was a strong interest by a number of parties, other parties, for the US and the others to open up their small business programs to all the parties. That did not happen during the negotiations, and it was a very contentious issue. So to continue that discussion and not just sort of say, close the door, and walk away, we set up this SME work program in part to sort of see what everyone else was doing and try to exchange information on SME programs and look to see whether there was any way forward that would be more progressive in terms of providing more access to the other parties. So that was the impetus for that one. Another one was on sustainability. And on that point, the parties didn't have the same views as to what sustainability might mean. And this was, before climate change had become such a big issue and where government procurement's role in how it could address climate change had not really come to the fore. So rather than trying to spend more time trying to work out the sustainability issues in the negotiations, we put it into a work program. And so those are two. A third one was a common problem for everyone. And this is the one on statistics, which is probably one of the more technical work programs. And that one was designed to try to find an answer to the question that all the parties had of how can we best show that we are actually buying from each other? The parties sort of across the board, with maybe one or two exceptions, and the exceptions were not the US, did not have good information or good data to show that the parties were buying from one another. So we thought if we had a work program that could really dig into this and the parties could share their expertise, that we would do so. So that was really, I think, a common interest, and it wasn't sort of so contentious. It was a hard one. Now, as to why these work programs after a decade really have shown no results from what we on the outside can see, I think points to sort of two things. One is they're facing really tough issues. We couldn't resolve them in the negotiations after a decade. And so, you put them into a work program and sort of hope that somebody's going to find a path forward. But it's not easy. And so whether that was the best approach, that's questionable. I mean, we could have just left them on the side. We put them into a mandate because there was a concern, at least for the, part of the more controversial ones, the SME programs and the sustainability, that if, we'd spent all this time talking about them, we'd agreed to do a work program. Let's just put it in a mandate so it happens, rather than just kind of getting lost. Because, often in negotiations, if you say, well, we'll take this up later, and you don't have it written down, it doesn't happen. Or else you have to fight to get it back on the agenda. So that was the reason. Whether they were really a successful approach, it's a good question, and probably not. Hopefully that the parties will find some mechanism for moving forward, particularly on sustainability, now that climate change is considered so important in government, procurement could be a leverage for addressing it. But I think, looking back, it was the best that parties could do at the time. Rather than just ignoring an issue, they said, okay, let's plan to have a sort of focused discussion on it. But a decade later, questionable whether that was the right choice.
Well, thank you, Jean. You mentioned environment considerations in the context of the work program on sustainable procurement. So that allows me to make the link to my next question. Another interesting aspect of the text of the GPA 2012 relates to the new and explicit references to the conservation of natural resources and the protection of the environment in the context of provisions, for example, on technical specification and evaluation criteria. So if I may ask you, Rob, could you please explain why those references were added in the new text and why they were important?
Well, I think, thank you, Philippe. I'm going to say that I think those changes were very important, and not so much because they were perhaps strictly needed in a legal sense, in the sense that I would argue that the GPA, even as it was previously written, was not particularly a barrier to the implementation of measures to promote sustainability. However, I think the parties wanted, and I think they were just absolutely correct in this respect, they wanted to send a signal, in part a political signal, that this was a modern agreement that was sensitive to environmental values, and to send that signal that this agreement would not stand in the way of implementation of sustainability and eventually climate change mitigation. And I want to say also, like, thank goodness that they did this, because since then, since 2012, this issue has become so much more important, more salient, and more important, and now is important for the future of the world. So, and here also, so I'm really glad that the new language is there in Article 10 and elsewhere concerning protection of the environment and sustainability. Even though I think it maybe didn't change the situation legally, I think it was a potent and powerful political signal, and I'm really glad it's there. Now, here I would indeed make a link back to the work program on sustainability, which Jean mentioned, and that is, and Jean, I know you've, in your excellent blog post that you do, you've already mentioned the catalog, the EU-US catalog of measures concerning the promotion of green procurement, which came out just a couple of weeks ago. I think that is quite a useful step and a significant step forward. And I think it will be useful in the context of the work program. It will probably not resolve all the issues that need to be resolved, but it's a really useful and good thing that the US and the EU have reached agreement on, maybe we shouldn't say reached agreement, but have been able to come out with this joint publication, which references all the things that they're doing in the two jurisdictions to promote green procurement. And I think that's really useful and helpful. And I hope that eventually the measures being implemented by other parties will be perhaps included in a similar document as well. But, so I think we could have, or the parties perhaps could have gone further in 2012 to grapple with sustainability, but Jean is right. And there were different concepts of what sustainability is. I think the parties were right to put this emphasis on environmental language and to have that in the revised text. And I think of all the work programs, I think maybe the one on sustainability is the one that is making the most progress and can still lead to some very good, very useful outcomes.
Thank you so much, Rob. Now I would like to turn our attention to developing countries, as both of you know very well, to encourage accessions to the GPA 2012 by other WTO members, including developing country members. The GPA 2012 includes a new and improved provision on developing country flexibilities, the so-called transitional measures that can be negotiated by exceeding candidates during the accession process. So to address this aspect of the text of the GPA 2012, I would like to turn again to Jean Greer. Jean, could you please comment on this new provision for developing country members and how it has operated to date, please?
Thank you. Well, I think that the developing country provision was one of the most important additions to the agreement. And on that one, we were working really hard to try to think through what kind of transitional measures would actually assist developing countries. And we drew from some of our own free trade agreements and provisions we had included in those agreements, where we had found that in negotiating with a developing country in an FTA, that they need a certain kind of transitional measures or measures to help them kind of ease into taking on the agreement's obligations. So that was just a really important part of the negotiations. For instance, we added a provision that you could perhaps exclude sectors for a period, higher thresholds, preferences for small businesses or others. So this was something that was considered really important, and we spent a lot of time on it. And I think what's particularly important about this provision is that, the growth of the GPA is going to depend upon developing countries, because now the parties are basically all what you might call developed countries. So the future of the GPA's expansion is going to be on developing countries. And so the challenge for the GPA parties is to say, do we have the right provisions in this agreement to attract developing countries? To date, since the agreement the 2012 amendment went into effect, only one party, Moldova, has been allowed to put in a higher threshold or higher thresholds as a transitional measure. But Armenia, Ukraine, Montenegro all joined without any such provisions. Now, I don't know whether they asked for them or not, but I think the key for the parties is to figure out, and probably in talking with non-party developing countries, to say, what exactly in the GPA is holding you up from joining? And are there adjustments we could make, whether it's transitional measures or other provisions, that would make the agreement more attractive to you, because the developing countries are the future of the GPA. Rob, did you want to add anything there?
No, I agree completely with everything you just said, Jean. Yeah.
Thank you very much, Jean. To address my next question, I would like to invite both Rob Anderson and Jean Greer to share some thoughts. As you reflect on the GPA 2012 renegotiation, do you have any regrets? Do you see any missed opportunities or aspects of the agreement that should have been addressed for the first time, or at least clarified back then? Or even if as you take into account the first decade of implementation of the GPA 2012, do you see a case for making further improvement to the agreement? As you both know, this is not just a wishful thinking. The GPA 2012 does include a mandate for further negotiations. Rob, would you like to go first?
Sure. And so I'll begin by saying boldly that I have no regrets at all. I think the 2012 renegotiation was a tremendous success for the parties. and I think they broke new ground in many significant ways, which we've mentioned. Good governance, prevention of corruption, developing countries, as Jean has mentioned, and sort of the modest new language on environmental protection, and just generally, as Jean also emphasized, a more coherent, user-friendly, easier to read and understand and implement agreement. So I think it was a terrific success. No regrets. I do have a few points that where I see opportunities to carry forward the work that was done. And definitely, first and foremost, I would mention the environmental element of the agreement. And I think that even though it was a great start in 2012, what was done, the new language on technical specifications and criteria, but more needs to be done. More could be done. For example, there might be a reflection of the importance to be given environmental values in the selection of suppliers or qualification. These are just some quick and easy possibilities. And I think eventually what would be more challenging, but what I hope might be done, is to find some way to actually incentivize in the agreement, incentivize the implementation of green public procurement. In other words, give due perhaps, for example, to give due recognition to efforts to implement green procurement in accession exercises. That would be something that I think is worth exploring. Obviously, a lot of thought would have to be given to it, but I think it's something that could be discussed. And there's a couple of specific little elements of procurement policy. Well, they're actually not so little. One is framework agreements. This is not currently mentioned in the revised GPA text. And I respect the fact that, there were differences in perceptions amongst, I think, the US and the EU about what to do in that area. But I think this topic of framework agreements is very important. And I hope that in the next round, there might be a specific provision dealing with this important procurement method and to uphold the values of competition and transparency in the use of framework agreements. Likewise, I think that more could be done to address the topic of public-private partnerships. I realize that there's some references to some types of PPPs in some of the parties' schedules, but I think we ought to discuss that even in the text of the agreement and set some basic principles down for the conduct of public-private partnerships. These are the ones that come. Oh, and in the area of good governance, I think it's, as I've already spoken too much about what a breakthrough I think it was to have the new language on corruption. And I think also the topic of collusion amongst suppliers, which is kind of a counterpart to corruption, but collusion amongst suppliers also deserves a little bit more attention in the agreement. There's a passing reference in the provision on limited tendering, and that's great, but I think that the desirability of measures to prevent collusive tendering arrangements among suppliers could also be reflected. And maybe one last thing, I think we should, in the agreement, recognize the importance of post-award contract management. It doesn't need to be too long or laborious, but post-award contract management is super important to delivering good results in public procurement. And I just think that the GPA should mention this even in possibly a very modest respect, just to remind everyone of the importance of that aspect. That's what comes to mind now. Sorry, Jean, over to you.
No, I would just agree with what you've said. I think it's the text is now 15 years old from when we closed it in 2006. So it could also be just sort of looked at as to whether it still reflects current practices, and the time frames might have to be re-looked at as well. Mm-hmm. But otherwise, it was an excellent summary, Rob.
Thank you.
Many thanks again to both of you. We're coming towards the end of the session, but I think it will be appropriate before we finish this to give both of you an opportunity to share and sum up what you personally see as the main achievements that were brought about by the GPA 2012. Or alternatively, if you prefer, feel free to tell us about a little anecdote from those intense days of negotiation. Should we start with Jean on this occasion?
Okay, I'd make two comments. One, I think the importance of the 2012 revision is the fact that the GPA has become the gold standard, and it's referred to in many ways in many free trade agreements, whether the parties are, or the parties to the FTA are parties to the GPA or not. I was recently looking at an agreement between India and the United Arab Emirates, which incorporates much of the GPA, even though neither of them are GPA parties. And just as, I suppose, as an anecdote, one of the fun parts of the negotiations was how we approached working on the text in the room. I think perhaps for the first time in the WTO, we put the text up on the screen at our sessions, and we had a very able secretariat staff person, Yanis, who would then, as we proposed things, put them up on the screen. And so all the parties could see right then what was being proposed on the floor and make changes or comments. And that just made it a very dynamic, inclusive process. So it wasn't just, the Quad sitting in a corner negotiating among themselves. It was including everyone in the process. And I thought that was just one of the really good aspects of the negotiations, and was just very grateful for the Secretariat's willingness to let it happen.
Thank you very much, Jean. Rob, would you like to add a few points?
I certainly agree strongly with everything that Jean has just said, especially about the GPA being the gold standard internationally and actually having an importance that even goes in an odd way. The GPA is important not only just for the GPA parties, but for the example it sets and for the reflection of its language in bilateral and regional trade agreements. And I think that's a really excellent point made by Jean. I just want to, just as a closing thought, and I just want to come back to this thing that we mentioned earlier, that even up until the morning of the adoption of the results of the renegotiation, first in 2011, and then subsequently the sort of after the legal check and everything else in 2012, that we weren't actually sure that it was going to go through. We were very, very hopeful, and people had worked their hearts out, including delegates, and the Secretariat had been there with them. But it wasn't over until the chairman's gavel fell. And a personal recollection of mine that I don't think I'll ever forget is talking to Jean on the phone, because she was there, obviously at the U.S. mission. I was there in my office in the Secretariat, and I think I remember talking to you, Jean, around, first of all, around 1:30 in the morning, to just touch base and kind of do a mini checklist of loose ends that still had to be tied up. And then I recall speaking to you again, well, then I went home for a couple of hours of sleep, and then I came back to the office, and I think we spoke again on the same topic around 5 o'clock in the morning. So that's how intense it gets. And you know, I know you and other delegates were going flat out to make this work. We in the Secretariat were trying our best to help. The DG at the time, Mr. Lamy, Pascal Lamy, also got involved in calling a couple of delegations at least to ensure they were fully on board. And it truly took the village and everyone in it, all the parties, the DG, the Secretariat, to make it all happen. And even then, it wasn't totally assured until it was assured and a done deal. Thanks for the pleasure of sharing these thoughts.
Many thanks to both of you. That was really, I think it was a very insightful discussion. Before concluding the session, I really want to warmly thank each of our distinguished panelists, Jean Illman-Greer and Rob Anderson, for their time and excellent contribution. So thank you indeed very much for that. Let me also thank all of the participants for their interest. All the best and goodbye.